Public data is information often printed and shared in directories. It includes personnel data or information on compensation and assignments. Public student data includes information such as name, address, telephone number, dates of attendance, grade level, etc. Private data is information directly related to a student. It is gathered and kept in a student's educational record. This data is accessible to students and parents and guardians, as well as school staff, on a need-to-know basis. Data such as information identifying a student's race or religion, academic courses completed, level of achievement, test scores, health data, special education placement, and program information are examples of private data. Confidential data is information not accessible to the public, parent or guardian, or student. This data is not placed in the student's records. Examples of confidential data are records from outside agencies deemed confidential, reports pertaining to neglected and/or physical and/or sexually abused children, and investigative data. When this information is placed in the student's cumulative file, it becomes private data. Teachers often keep information that is never shared with parents, guardians, students, or other staff members, except a substitute teacher as needed. This information is considered desk drawer data if it meets certain criteria and is an exception to the normal data privacy rules. This data is to be kept for no longer than 1 year. If it is kept for more than 1 year, it becomes part of the student's private file. The record of inspection is a log sheet used to document what data has been inspected, by whom, and why. When staff members view certain data, they must sign the record of inspection log sheet. It is important to protect student data, to keep it under lock and key. Discuss students only in private and with only the staff directly involved in the student's program. Remember, a parent's guardian's right to information is limited to their child only. Except under certain circumstances, in order to share information with an outside agency, you must have a signed release. A subpoena is not enough to provide not public information. A court order is required to release student information. A parent or guardian release is generally not required for disclosure if data is for school officials or a teacher within the district who have a need to know. If the information is going to a school or post-secondary institution where the student plans to enroll, for authorized government officials, in connection with financial aid, for organizations conducting studies on behalf of educational agencies, for accreditation organizations, for the parents of dependent students, in compliance with judicial orders, in an emergency health situation, for directory information, or to administrators of immunization programs. Districts must review their data privacy policy annually and notify parents and guardians and students of their rights. Districts must establish data collection and retention procedures. Private and confidential data must be collected and used only for the purpose intended. In the case of a dependent student, both parents, mother and father, have the full right to inspect educational records unless the district has been provided with information to the contrary, such as a court order concerning child custody. Districts must provide copies of records when requested. Districts must respond immediately if possible, but have 10 days to comply with requests to inspect. Parents or guardians may request the district to explain some or all of the records. Districts may charge a reasonable fee for copies unless cost prevents parents or guardians or students from exercising their right to inspect. When the student reaches the age of 18, data privacy rights generally transfer from the parents or guardians to the student. There are consequences for staff that breach data privacy. A breach of data privacy by an employee could be a misdemeanor, and he or she is subject to criminal prosecution. A privacy violation is automatically just cause for discipline of the employee, and the complainant may recover significant damages plus costs and attorney's fees. The most common violation of the Data Privacy Act is the unlawful disclosure of information.